Our wrap-up speaker is Margaret Ryan, who's going to talk about fact witnesses. Again, after she is done, the three panelists will be happy to take some questions from the audience. So, Margaret, thank you very much for coming.
Hello. Thank you very much to the Journal for the invitation, and I'm delighted to be back in Montreal and very, very honored to be speaking among such esteemed colleagues. So my remarks this evening will be focusing on some of the practical dimensions of preparing fact witness statements in international arbitration. I'll first look briefly at the function of fact witness testimony. And then I'll also discuss some of the ethical considerations of surrounding the involvement of counsel in working with fact witnesses in the preparation of their statements. And then following from this, I'll be proposing some best practices for preparing fact witness statements. I'll be drawing on my own experience practicing international arbitration for 5 years, but given that I'm here with people who have been practicing for much longer than I have, and also there are some arbitrators in the audience. I'd be very interested in their views on these topics during the question and answer period. And I'll just repeat Stephen's comment that I'm speaking to a mixed audience, so of both students and practitioners, so I apologize if some of my comments might seem self-evident to some, but I hope that in any event they'll generate some discussion. So fact witness testimony, it can be a very, very effective means of presenting evidence and of bringing a case to life. And that's particularly true of large complex disputes with documentary records with evidentiary records that are large. And it is indeed often said that cases are won or lost based on fact witness testimony. And that's particularly true at the stage when the witness appears at the hearing to give oral testimony. In short, testifying witnesses are unpredictable. Witnesses often succumb to the pressures of cross-examination, they'll go off course, and they'll deviate from their written testimony. So how counsel approaches both the selection of witnesses who they will put forward to give testimony, and also how you prepare the written witness statement can significantly mitigate these risks. An effective written witness statement will make the cross-examination much less stressful for the witness, and it will assist in effectively conveying the strength of your case to an arbitral tribunal, and also shape the tribunal's overall impression of your party's position. So looking just briefly at the function of fact witness testimony. Today, fact witness testimony is a regular feature of international arbitration, despite the less frequent use of fact witnesses in some civil law jurisdictions. And the widespread practice in international arbitration is that a witness will submit evidence first in written form as the evidence in chief, prior to giving oral testimony at the hearing. And so submitting written fact witness statements is expressly contemplated by most institutional or ad hoc arbitral rules. So you can see the provisions of the IBA rules, Article 4, also the LCIA rules, the AAA, ICDR rules. And it is also widespread practice in arbitration conducted under the ICC rules, even though the ICC rules don't make any express provision on fact witnesses. And it has been recognized that reducing a witness's testimony to written form has a number of procedural advantages. Before the hearing, during the written phase of the arbitration, fact witness statements will serve to bring the disputed issues into focus. Having the witnesses submit written statements along with the submissions will allow counsel to choose which witnesses they eventually want to cross-examine at the hearing. And based on the content of those statements, counsel can efficiently choose the issues they wish to traverse during cross-examination. At the hearing, because the written witness statement will replace the witness's evidence in chief, this will lead to savings of time. Usually in practice, witnesses' direct testimony will simply confirm the content of their written statement. And it will also allow the tribunal to narrow the issues that are debated at the oral hearing, because generally the questioning of a witness will be limited to the issues that are raised in their witness statement. And as I mentioned, fact witness testimony in general has other important advantages. It can bring the facts of the case into logical and consistent form. And indeed, in most cases, the documents of the file will not cover all the facts that are relevant to the dispute. And so by ordering and supplementing the documentary record, fact witnesses can really assist the tribunal by giving a full description of the relevant facts. And fact witness testimony is incredibly compelling. It's a form of storytelling, and it can really assist in conveying, again, the strength of your party's case to the tribunal. Just looking briefly at some of the ethical considerations surrounding the involvement of counsel in preparing witness statements. Today in international arbitration, it is widely accepted that counsel will be heavily involved in the preparation of fact witness statements and also in the preparation of oral testimony before the hearing. This is, however, not without controversy, and it's still common to hear arguments, particularly from practitioners from civil law backgrounds, that this involvement of counsel raises ethical concerns. And the concern here really is that the lawyer, when working with the witness, will unduly influence the witness, will corrupt his memory of the relevant events, and carry his testimony further away from the truth, and that the witness will drift into advocacy. So this topic is widely discussed in international arbitration. As Stephen mentioned in his presentation, counsel are often from different jurisdictions and legal backgrounds and will be governed by different ethical norms, including ethical norms that provide different rules on the propriety of working with witnesses in the preparation of their testimony. And both the IBA guidelines on party representation, which were adopted in 2013, and the IBA rules of evidence adopt a transnational approach to these issues. And again, it's part of the goal is to create a more level playing field between practitioners from different jurisdictions. If you have an American lawyer acting in the same arbitration as a lawyer from a civil law jurisdiction, if the American lawyer were to follow the rules that govern the preparation of witnesses in the United States, where it's pretty much considered professional negligence if you don't heavily coach your witness, they would be at a significant advantage. So the guideline 20 of the IBA guidelines on party representation provide that a party may assist a witness in the preparation of the witness statements. Guideline 24 also provides that, consistent with the principle that a witness's testimony should reflect its own account of the relevant facts, events, or circumstances, a party may meet with the witness in order to discuss and prepare their prospective testimony. Article 4 of the IBA rules similarly provides that it shall not be improper for a party to interview witnesses or potential witnesses to discuss their prospective testimony. And many commentators have noted that the involvement of counsel is actually necessary for the witness to give the clearest and most complete account of the relevant facts. In the words of Laurent Lévy, who is a Swiss-based arbitrator, arbitrators would not actually benefit from a statement which the witness drafted on his own. The help of counsel enables the witness to focus on the relevant issues, which in turn proves a useful tool for the arbitrators. So then, turning to some guidelines for counsel in assisting witnesses in the preparation of their testimony. Well, the first step at a very early stage of the arbitration is to choose which fact witnesses you wish to put forward in support of your party's case. And here I would make two recommendations. The first is to select the fewest number of witnesses necessary to prove your case. And this is a golden rule that at least I've followed and my team has followed in every case that I've worked on. I'd be interested in hearing other people's views. But why, in our view, have we always selected the fewest number of witnesses? Well, there's a very practical reason for that, is that each witness that you will put forward will consume a significant amount of your time, both in assisting the witness in the preparation of the statement and also preparing the witness for the hearing. And certainly it's unrealistic if you're busy preparing for the hearing or drafting your memorials to be working on 5 simultaneous fact witness statements when they cover many overlapping issues. And of course, each additional witness will also bring additional risk. By submitting a statement, you are exposing a fact witness to cross-examination by opposing counsel at the hearing. And as I've mentioned, this is unpredictable. It can go very wrong. So at least in our view, in my view, I think it's always good practice to limit the number of fact witnesses you will put forward. In the same connection, it's usually a good idea to avoid putting forward more than one witness in relation to the same set of facts or issues. And I've seen the strategy of sort of seeking strength in numbers by submitting several witnesses in relation to the same facts go quite wrong in one arbitration, where a central issue and dispute was a decision that was taken at a meeting of a board of directors that had not been reduced to any written form. And the opposing counsel put forward 2 witnesses who gave pretty much the exact same account of the meeting in their statements. And when it came to the hearing and it was time to cross-examine them, it was an excellent opportunity to exploit contradiction between their oral testimony, which ultimately led to discrediting both witnesses. And perhaps if opposing counsel had only put forth one witness in support of those facts, we would not have been so successful. You might also consider that where the documents adequately tell a story on a certain issue or fact, a fact witness might not even be necessary at all. So the second guideline concerns which witnesses to choose, and this may seem self-evident, but one should always select witnesses based on his or her direct and detailed knowledge of the relevant facts. In practice, most witnesses in international arbitration will be employees or former employees of the disputing parties. And Article 4 of the IBA rules provides a very broad, liberal definition of who may be a witness in international arbitration. Any person, and provides that any person may be a witness in international arbitration, including a party or a party's officer, employee, or other representative. Now, this stands in contrast to domestic rules of some jurisdictions that will not admit a statement of someone who has a significant relationship to one of the disputing parties. And I think there are very good reasons for allowing parties to appear as witnesses. They'll often have access to certain facts or documents that other individuals would not have. But it's also important not to lose sight of the rationale behind this prohibition, which is namely that the testimony of a party witness is assumed to be partisan. So in selecting, while I say that it seems self-evident to select a witness based on his or her detailed and direct knowledge of the relevant facts, it often happens that witnesses are chosen based on other criteria. Often you will see witnesses selected based on their seniority in a company, for example. And I've seen in an arbitration a senior executive of a company being put forward as a fact witness. However, he only had a very, very general knowledge of the relevant facts in dispute. And I think the assumption underlying the choice was that he would be more presentable to the tribunal, perhaps he would have more charisma and be more persuasive. But ultimately, his testimony was not persuasive at all, because it emerged during the cross-examination that his knowledge of the dispute was received secondhand. And also, it seemed also that he was used to being treated with a bit more deference than he was receiving during his cross-examination. And at one point during the examination, he became rather uncooperative and hostile, which I don't think the tribunal received particularly well. And also from a practical perspective, usually senior members, senior executives in a company will have less time to invest in the preparation of their testimony, and they'll also spend less time familiarizing themselves with the documents in their statement prior to giving oral testimony. So unless a major corporate decision is at issue in your arbitration, it's usually a mistake to choose a witness based on seniority. You're going to have more success with a middle manager who will appear much more knowledgeable and honest and really lacking in any agenda, and so will ultimately be more persuasive as a fact witness. So now just to raise a few points concerning the preparation of the written witness statement. Even though it's accepted that counsel will be involved and assist with the preparation of witness testimony, it's always best practice that the witness remains the author of the statement. And in a chapter of the book, The Art of Advocacy in International Arbitration, Pierre Bienvenu and Martin Valasek write that a lawyer should practice invisible advocacy when working with fact witnesses. As they write, the aim of invisible advocacy should be to allow the witness to discover and amplify the witness's own voice, and not to bury the witness's story under layers of facts construed by an overzealous lawyer. So the art of invisible advocacy has many facets in practice. And first, I would say that wherever possible, the witness and not the lawyer should prepare the first draft of the witness statement. And in practice, this will involve asking the witness to prepare a full written account of everything that they know that is related to the dispute and about what kind of information they have about the dispute. When this isn't feasible, when there's not enough time or the witness is too busy or feels uncomfortable performing this exercise, you can also conduct an interview with the witness, asking the witness open-ended, non-leading questions concerning the relevant facts and events, and then based on the notes or transcript, you could prepare a first draft for the witness's comment. But in all cases, the lawyer should not prepare a first draft of the witness statement without any input from the witness, and then submit it to the witness for his or her comment. This raises clear ethical concerns, but from a strategic standpoint, arbitrators, especially very well-seasoned arbitrators, can easily spot a witness statement that has been prepared by lawyers, and will not place much weight on this type of statement. And this type of statement will also often not withstand scrutiny during cross-examination. And so the absolute nightmare situation is where a witness is confronted during cross-examination with words or phrases from the statement that he or she doesn't understand. And this includes colloquial expressions or certain legal terms that may have been inserted by the lawyer during the preparation of the statement. And a colleague has told me a very funny anecdote in one high-stakes arbitration where counsel suggested to the witness that he had not authored the words in his statement, tip of the iceberg, because icebergs were unknowns in the witness's tropical country. Very much to the relief of opposing counsel, the witness explained that he was indeed familiar with the expression icebergs because he had seen the movie Titanic and had used the expression to convey that the fraud at issue in that arbitration was buried beneath the surface. But he may have not been so lucky if a different expression had been used in the statement. And then just a final note, where English is not the witness's first language, or the witness does not have a good command of English, the statement should first be prepared in the witness's own language and then translated into English. And the new IBA rules provide at Article 4.5c that the statement should indicate in which language the statement was originally prepared and the language in which the witness anticipates giving evidence at the hearing. So just a few comments on the substantive aspects of improving the first draft of the witness statement, because it's clear that any first draft of a statement prepared by a witness will not be in a form that can be submitted to the arbitral tribunal. So how can you work with a witness to bring out the best possible testimony? Well, the first thing that you have to do is signal errors in the statement or any inconsistencies between the witness statement and the documentary record. And this is really the lawyer's responsibility, because it is the lawyer who will be familiar with the universe of documents in the arbitration. Second, add references to contemporaneous documents which the witness authored or reviewed at the relevant time of events. A witness statement should not be based solely on the witness's recollection of events, and bare and unsubstantiated statements can easily be targeted on cross-examination and lack credibility. A third aspect of the editing process, which is very important, is to remove all unnecessary details from the statement. Care should be taken that the statement does not stray beyond any of the necessary relevant facts that are in dispute. Arbitrators are very busy people, and long, convoluted statements that contain long passages of irrelevant testimony are generally not well received. And also, having too wide-ranging a witness statement will open up too many doors and expose the witness to various lines of cross that may not ultimately be helpful to your case. And then finally, you can also consider how testimony can be rendered more accessible. Diagrams, for instance, are particularly helpful when a fact witness is testifying about technical issues that are difficult to describe. You can also consider using a glossary of technical terms. And then my final recommendation would be to acknowledge the participation of counsel in the statement itself. And I've seen this done more and more in the arbitrations that I've worked on. And this can be just a matter of inserting a simple statement at the end of the introduction to the statement that counsel has assisted me in the drafting of this statement. And you should always ensure when working with the statement, with the witness, that the witness is entirely comfortable with acknowledging the assistance of counsel if asked about this during cross. And this is really not something that the witness feels that he or she needs to hide. So that concludes my remarks. I'll be very interested in hearing whether you also have some proposed best practices based on your experiences as well. Thank you.
Thank you very much.